is many of our teams develop a name and a logo, and they might go through 3 or 4 different names and logos as they go through the program, but they often don't think to check and see if either of those are protectable. And then when it's time to go to market and they sit down with you, they realize that some work needed to have been done to lock up what they were planning, and that they might have to let go of something that they cared about because somebody else is using it or it's used in another related industry. So I think it's helpful to just talk a little bit about what these folks should be thinking about as they choose a name. And it could be a working name, and maybe it's not important until they actually go through the process of incorporating and then locking things up. But if it's something they're really invested in and they really want to see as part of their eventual venture, what they should be thinking about.
And that's a conversation that we routinely have quite early on in a venture's formation. The prospect of creating a name, creating a logo, having an identity in the marketplace, one that the team is usually quite proud of and identifies with, is interestingly usually a conversation that we have before we talk about other types of intellectual property assets. And the conversation really needs to be around a branding strategy. It's not enough to look at names and think about that before you really invest in it. And the investment takes a lot of different facets, if you will, or a lot of different forms. It's everything from, the money in your branding to your materials, to the cost for a graphic designer for the logo. You should really understand what's out there in the marketplace. If you go to the Canadian Intellectual Property Office website, you can look at the database for trademarks, and that will at least give you an idea of what's registered. It won't give you anything because there still are marks that are being used with common law rights. Another thing it won't give you is, and this is interestingly quite important as well, is the purchase of your domain name. So including your domain name in that strategy is quite important, and to lock that down at the same time will save you a significant amount of potentially a significant amount of pain and cost for the purpose of avoiding cyber squatting. We have a nice side business going on challenging cyber squatters, if you will, through Canada's process, their domain name dispute process. We find lately in Canada that upon the application of registration for a trade name, there are those that are watching for those applications and go out immediately and buy up domain names for the prospect of exploiting or extorting the owner of that trademark at a future date for the domain name. So it's more than just the name. There's quite a scope to that conversation, and domain names, frankly, are quite inexpensive. Usually you can get a bucket of them for $100. So I would really encourage the ventures to give that a broad and thorough consideration.
I'm so glad that you brought that up. It takes about 5 minutes to protect a domain name, and I can't tell you how many teams I've sat down with who are out actually in the marketplace creating pilots and doing user testing of their minimum viable product, and they have not locked up that domain. So I'm glad you raised that. Trade secrets. Can you talk to us a little bit about trade secrets?
Well, sure. So trade secrets, as we said earlier, is a subset of confidential information. The point of distinction is that trade secrets derive their economic or commercial value by virtue of being secret. Typical examples, and these are consumer examples, are recipes like Coca-Cola or Kentucky Fried Chicken. But I can certainly attest to the notion that trade secrets are also calculations, methods data sets in databases, molecular compositions. It really can span quite a broad range of assets that drive commercial value.
Last area I'd like to cover is confidentiality. We touched on this briefly when we talked about employees and contractors. As our teams move to the end of the program, they begin to focus on strategic partnerships. They're bringing on team members. They're talking to angel investors, venture capitalists, grant funders, and they begin to be interested in getting NDAs signed, and some parties will sign them and some won't. Can you talk about that piece of being prepared as a business and what the factors are?
So that's, confidentiality is quite a conversation. And a couple of considerations for ventures embarking on these formative introductions, networking discussions. The first is to really recognize that the best protection for information that provides you with a competitive or commercial advantage is to keep it confidential. Don't disclose it. Top of mind for teams should be managing their disclosures of confidential information. Consider first whether a disclosure of confidential information is actually necessary to further the discussion or the business opportunity that is present, or will non-confidential disclosures suffice? Where a disclosure of confidential information is essential, really the point there again is to still manage that disclosure to limit the amount of information that is actually disclosed. Second, where it is essential and you have to disclose information of value, put a non-disclosure agreement in place to provide a basis for aligning your interests with the counterparty. And the alignment is clarity on what you consider confidential and what is important to you, and for the other party as well. This agreement also provides an evidentiary basis for enforcing protection of your confidential information and obtaining remedies in the event of a breach of the duties of restricted use and confidentiality. Now, you mentioned that given the startup community and the way it operates, there are some investors that won't sign these sorts of agreements. And that's correct. I wouldn't say that it's all of them, but many do. And an example, certainly in this community, is the Valhalla Angels. They simply won't sign an NDA as a matter of practicality. They are dealing with so many entrepreneurs that to have to accept the burden of signing, administering, and managing their affairs in accordance with what could be hundreds of these agreements just doesn't make any sense. That doesn't mean, however, that you can't protect yourself. The best thing in that sort of circumstance is, number one, to put the other party on notice that the information to be disclosed is confidential. Say, for example, you're about to give a pitch. Declare that at the beginning of the pitch or conversation. To the extent that you're using materials to further or illustrate that conversation or support it, have a stamp on those materials that is conspicuous, identifying it as confidential, particularly if you're going to be leaving a copy behind or distributing one. And keep a record of the date, the time, the identity of the recipients of the confidential information, and what confidential information was disclosed, just so that you've got clarity on managing that pool of confidential information. In this way, you may not have a written agreement, but you certainly have set up yourself with an evidentiary basis under the common law for protecting your confidential information.